Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thank you, Ronnie. Morning. Happy Friday to you all. Welcome to the Massachusetts Appeals Court. My name is Judge Desmond. To my left is Judge Smith. To my right is Judge Brennan. We'll be your panel for all 5 cases today. We have one case, I believe it's our 4th case, that has been impounded. So we want to make certain that we don't use any names or identifying information in that matter. I see some familiar faces, so I suspect you all know the rules. 15 minutes per side, no rebuttal. We familiarized ourselves with the facts and most of the case law, so you need not spend a lot of time on the facts, but your 15 minutes is indeed your 15 minutes. Feel free to use it as you see fit. We'll probably take a break after our 3rd case and then come up and wrap up the last 2 cases for the day. Our first case is 23P0097, Commonwealth versus Ryan Vibber. Mr. Luskin.
May it please the court, Cass Luskin on behalf of Ryan Vibber. Your Honors, this case is about 2 preserved errors, improper evidence and improper argument. The improper evidence is the admission of pseudoscience, a simple directions test that was invented to comply with the requirements of Commonwealth versus Sands, but was presented with an aura of scientific validity. The improper argument is a textbook example of burden shifting, Your Honors. In closing argument, the prosecution not only commented on the absence of a potentially favorable...
Turn that, you're kind of talking, you turn that mic toward you. There we go.
Absolutely. My apologies, Your Honor. Is this better?
A little bit better, yeah.
I can also lean down a little bit. The improper argument is a textbook example of burden shifting, where the prosecution during their closing not only commented on the absence of a favorable defense witness, but described that absence as notable. These errors obviously, I believe, are independently sufficient to warrant reversal, but the combination of them under Commonwealth versus Cancel compels reversal as well. I'll take them in turn. With respect to the improper evidence, Your Honors, the admission of a simple directions test or a follow the fingers test, it's simply pseudoscience. It's not validated. There's no study, there's no standardized method for its administration. While I understand that it was necessary in order to comply with Commonwealth versus Sands and that observations of an officer may be admissible, the presentation of those observations as a test, the presentation of those observations as part of a battery of tests, and is what the prosecutor described in his closing as the special, subtle science of alcohol intoxication, is an error.
So can I ask you, your issue is not so much with the activity itself, but with the characterization of it, is that fair?
Absolutely, Your Honor.
So you have no problem if they go out there and say, follow my finger, but don't move your head, and then when they go like this, saying, clearly couldn't follow my directions, and then arguing common sense-wise what that might indicate as far as someone's level of impairment or awareness. That's okay.
Your Honors, I would push back a little on that. It's not clear to me, unlike many of the officer observations that occur on scene, if someone falls over or they fumble with their license, that the inability to hold your head still while moving only your eyes is in fact indicia of intoxication.
What if you say, put your hand over your head and instead they twirl around 6 times?
Absolutely, and officer observations, I think, are obviously going to be admissible. It reminds me if the officer had asked someone to kind of rub their stomach and pat their head at the same time. I'm not sure that would be relevant if someone couldn't do that. However, observations are observations.
At the end of the day, that's for the fact finder to determine what value that has, right?
Absolutely, Your Honor. My issue is the presentation of these observations.
Well, you say the presentation,
or packaging.
The characterization of it, again, back to Judge Brennan's question, which essentially is that they characterized it as a test. That's the issue.
Precisely, in exactly the same way that Gerhardt treats these field sobriety tests with respect to marijuana intoxication. They say you can't call them tests, somebody can't fail them, and then they can't be a basis for an opinion on sobriety. They're merely observations that can be relayed to the fact finder for them to do whatever they wish with it.
But wasn't it just an observation that the officer considered in forming his opinion?
Well, Your Honors, I'm not sure that the basis for the officer's opinion on sobriety, if we look at Canty, has to do with these specific tests, and there's limitations on the way he can express that opinion.
Well, the basis of his opinion not necessarily is just the field sobriety test. I mean, he stopped him for rolling through a stop sign, correct?
That's right, so, and a marked lanes violation.
Starts there. Why do we stop him? And so to determine whether or not he's going to arrest him, he observed him and administered some standardized tests, quote unquote, unstandardized.
Absolutely, Your Honors. And, yeah,
and all of those observations were put before the fact finder for the fact finder to assess whether or not they thought that he was impaired, right?
Yes, Your Honors.
So it's really just the standardized test language that you take issue with.
That's fair to say. It's the packaging, the proximity, and then the description of this as this special subtle science of alcohol detection. All of that imbues it with an aura of scientific validity that it lacks.
What do you think about the missing person?
Turning to the second argument, the missing person.
Unless you want to say a little bit more about the standardized
No,
test.
I apologize, Your Honor. I just didn't quite hear you. Your Honor, I think that the missing persons argument is really more properly thought of as a burden-shifting issue as opposed to a missing persons issue. I understand, of course, that there are cases on point with respect to a missing witness instruction. I would say that this witness wouldn't meet the foundational qualifications for such an instruction in the first place. This state trooper who apparently was in the basement taking care of his wife at the time of the party. But more importantly, when it's being used kind of offensively by the Commonwealth against a defendant, it implicates a number of constitutional concerns.
What about the discussion in sidebar? For better or for worse, you get 3 former trial judges here. So I think we've seen this once or twice, and a lawyer probably properly, politely doesn't object during the closing, comes afterwards and says, I'd like a curative instruction. And the judge says, well, are you sure you want that because maybe it's going to draw attention? DA says, well, fine by me. Lawyer says, on second thought, and I'm paraphrasing, maybe not. How is that preserving an issue? I mean, the lawyer could have easily said, well, you know what, I understand what you're saying, Judge, but I want an instruction. And in that case, it seems to me from context reading that transcript, the judge would have been fine with giving the instruction. So what am I missing here?
Well, Your Honor, I would suggest that perfection is not the standard by which we should measure the adequacy of an objection, and I would point the court towards the facts in Commonwealth versus Cancel, which is extremely similar to this. There was an objection that was lodged after closing. It was based on improper argument, and the defense counsel kind of affirmatively declined a curative instruction in this case, but perhaps more so even than happened in the instant manner, and that was deemed preserved. There's a subset of errors that obviously can't be fixed through instruction. You can't always unring the bell. NAAMIC collects a number of cases, but I think cases with a particular constitutional dimension, as opposed to an evidentiary issue or something more simple, can't necessarily be fixed either by a special instruction or a general instruction. And that, to me, obviously reading into the transcript a little bit, seems to be what everybody agreed upon, including the Commonwealth. I mean, everyone kind of said, if we say anything about this, we're going to make it worse. We're going to compound this error, so let's say nothing at all.
So, I mean, arguably that's how it unfolded. I'm not so certain, though, okay? Trial counsel asked for sidebar, said, I'm not looking for a missing witness, but I'd like a curative instruction. And so the judge took a run at a curative instruction, and they thought, well, no, maybe that draws too much attention to it. So the prosecutor took a run at a curative instruction and said, well, hey, point to both of us so as not to draw it just to one side. And they said, I'm not sure that fits either. And so the court said, well, maybe it's best that we say nothing. And the defense counsel said, okay. So what more should the judge have done?
Your Honor, I'm not certain that, I understand that court's position in this case was that the best outcome was to say nothing at all.
That was part of the discussion.
Part of the discussion, indeed, Your Honor, but I'm not sure what more defense counsel should have done.
They're the one who was asking for a curative instruction. They're the only one who didn't suggest one.
I would argue, Your Honor, that it seems unfair to require defense counsel to make their case worse in order to preserve an error that they've actually objected to. She highlighted the issue, she presented it to the court. No one could fashion a solution to it, but the error had already occurred. The bell had already been rung, and it had been rung in such a way during closing argument and with a particular constitutional gravamen that made it a significant enough error that it's the type that couldn't necessarily be cured with an instruction.
Hardly an unusual situation, wouldn't you agree? If you're trying cases, I mean, someone makes an argument that's clearly off over the line about a witness, and it seems to me it's a pretty simple instruction that if the defense attorney wanted it, just simply say, you focus on the evidence that's here. You heard from 3 witnesses or 2 witnesses on behalf of the defendant. Trooper, or whatever his cousin's husband wasn't a witness. Put that out of your mind. Don't consider it. Thank you. Next issue. I guess it seems to me that it was a passing reference and easily cured and or left alone in an either event. How do we get to the point where that had some significant impact on the jurors' decision-making process?
Well, I would give you 2 answers, Your Honor. First of all, the nature of the error is one issue. I think, obviously, as Thomas, in citing the Supreme Court, says it's an issue implicating a fundamental right. But with respect to the facts of this case, this is not a standard OUI case. I mean, obviously, there's defense witnesses that come and testify. There's 3 defense witnesses who testify to the individual's sobriety, including his aunt who let him drive her new car immediately prior to him leaving the house. And so in those circumstances, when you have 3 citizen defense witnesses who testify, calling the attention to someone with particular, he's a state trooper, he's going to have a special reliability, a special ability in front of the jury.
So now I'm going to push back a little bit, because you say 3 citizens. I mean, these were family members?
Yes, Your Honor.
Okay, so let's start there. 3 family members who he was at a party, I think it was a birthday party, for several hours. I mean, would you agree that the trooper who was the husband of one of the family members, I forget exactly whether it was his aunt or his sister, whoever, was kind of the elephant in the room? I mean, if you look at the video, he repeatedly is saying, I'm coming from my cousin, the trooper's house. I just left my trooper's house. I'm not really sure why I'm here. Can I call my cousin the trooper? I mean, we see that repeatedly in the video, right? So you don't think the jurors keyed in on that at all?
I think that they did key in on it. I think that's part of the issue. It's the Commonwealth who admits the booking video. It's the Commonwealth who extracts testimony about the homeowner and the nature of the fact that the homeowner is a state trooper from one of the defense witnesses. The defense never put this forward at all.
But none of that was objected to, right?
Well, the booking, there was a series of objections regarding the booking video, but I believe the court's right. That specific issue was not objected to. But given the fact that the Commonwealth has offered up this witness and then on the back end gets to comment on the witness's absence, seems extremely unfair to the defense.
I mean, I get it. Certainly better left unsaid, for sure. It was, I think, the last sentence of his closing, I believe it was. So that's the last thing that the jurors probably heard before he sat down. So I get it. Strong case for the Commonwealth, do you think?
Not at all, Your Honors.
Why not?
Well,
did he pass any field sobriety tests or any standardized tests or any of the tests?
no, he did not. In the testimony of the officers that he failed, he could not complete as administered the fall of the finger or whatever, the directions test they did, and the other 2 tests.
So we have an admission to drinking at a family party for several hours with a, seems like uncontested motor vehicle violation that he ran the stop sign, failed all of the tests. Why is that not a strong case?
Well, Your Honors, I would compare it, I think it's best viewed in comparison to other OUI cases. There's no accident, there's no chemical test, there's no gross deviation from motor functions, he's not falling over, specifically with respect to the standardized field sobriety tests. It's a reasonably borderline performance on these tests. He took too many steps on the walk and turn. He stepped off line 2 or 3 times. He had a bad turn, but he wasn't stumbling. He didn't trip and fall. This is not a huge failure. He failed on points. With respect to the one-leg stand, if my memory is correct, he was able to balance for the requisite 30 seconds. His foot was a little bit too high and he used his arms for balance. This is another situation where these are borderline performances.
Do you agree that you don't have to be falling down drunk to be driving impaired?
Absolutely, Your Honor. But with respect to strong cases versus weak cases, I think a borderline performance on a field sobriety test is relevant, and that's what we have here. The traffic violations, there's a marked lanes in addition to a stop sign violation. He's following a friend, as the testimony shows, to his friend's house. His friend takes a turn, he's trying to catch up with the friend, and the marked lanes violation is kind of an adjustment after making that turn. This is not a situation where he's gone off the road, where he's run into somebody or anything like that, which we frequently see in these types of cases. I'd also suggest that we've got a reasonably strong defense case as well. He stopped promptly and safely. He provided the license and registration without fumbling. There's only a slight odor and a very slight slur. He didn't sway or brace himself on anything. And then we have defense testimony. Those things together make this a borderline case. I'm not arguing sufficiency.
The jury heard all of that, right?
The jury heard it all, and I'm certainly not here arguing sufficiency, but I'm suggesting in the context of prejudice that this is a case that's near to or on the line, and as a result, these errors, maybe they wouldn't be sufficient for overturning a stronger case, but for this case, taken independently or taken in combination with each other, they are sufficient. Thank you very much.
I think we get it. Thank you. Well done. I believe that's your time. We'll now hear from Mr.
Yes.
Kidd.
Yes, good morning, Your Honors. May it please the Court. My name is Rob Kidd. I represent the Commonwealth in this case.
What do you say about, notably, the trooper's not here?
I would, my response to that would be you need to read that in the context of his closing argument, and that's one line in a repeated line where the prosecutor says, quote unquote, he repeatedly emphasizes, I'm coming from a state trooper's house. Why is that relevant? I think you can use your common sense why he might think that's relevant. But why is it relevant that he's coming from a state trooper's house? A state trooper who notably we didn't meet, wasn't here. He goes on. At one point, just to give a little insight about why he's bringing up that the state trooper says, quote, I'm saying I'm not going to save me, but I need to talk to him. That's the defendant in the booking room. I suggest that the main thrust of that entire paragraph is that this defendant was trying to get himself out of a jam by repeatedly saying, state police, state police, state police. He's on the booking video trying to call the guy who's at the party. I want to call him.
I get it. Your point's well taken. What does that have to do with notably he's not here?
That is an issue, that is a problem, but what I'm saying is, what would a reasonable juror infer from that? It was a very, very brief, I suggest.
When you say a reasonable juror would infer essentially what the prosecutor wanted the jury to infer, which is that there's a missing witness. I mean, that's a classic missing witness, not a huge argument, but that's the thrust of it, right?
No, that was not the intention. The prosecutor was not arguing that. He was just trying to argue.
I mean, he was one question away from laying the foundation for it.
He didn't, and he closed with, as I said, he closed with the quotes from that defendant. I need to talk to him, save him. So I think he was trying to tell the jury that this guy you should look at his credibility. He knows he's got a problem and he's trying to get himself out of a jam. The defense attorney never objected to that type of argument.
It's certainly fair for the Commonwealth to comment on the video evidence, right?
Yes.
There's nothing inappropriate about that.
Yes, and they did. That one line, I will concede that it was unfortunate that he had to say that one line. But in the context of the entire trial and using as we know, where closing argument is taken in the context of the entire trial, we are dealing with the prejudicial error standard. The judge had a number of options in front of him to hear in this case. He could have stricken the testimony. He had a sidebar with counsel. All counsel agreed that she shouldn't strike the testimony. In fact, defense counsel herself said, do you think that may draw attention to it? And so she's the one who had doubts about it. And it's also telling that counsel described this as, she said that when she went to the sidebar, she said, you know, the defense attorney, the prosecutor touched upon missing witness. And she used that phrase. And that tells me, you know, as a practicing lawyer, she was a practicing lawyer, that, you know, this wasn't perhaps a huge problem in her mind. And then that probably convinced her that, you know, maybe it was better left alone. So you look at that, and then you look at
Significant enough for her to ask for a sidebar, right?
Yes, yes. But she didn't interrupt the closing, which was, you know, understandable.
Courteous, right?
Courteous, but perhaps if it had been a horrible error, she might have jumped up and, you know, so there's that. And then, you know, you look at the factors.
We're not going to falter for being polite.
I'm sorry?
We're not going to falter for being polite, are we?
No, we should not do that in this day and age. So I would, you know, you look at the factors, again, these are the alternatives the judge had. So, you know, she's got this conference here with these lawyers, and it seems like everybody agrees that the best course of action here is to do nothing. And then you have to look at the factors of the case. Yes, the strength of the case. It is not the strongest of the case, but strongest of cases. But I suggest there's a theme in all the tests of inability to follow directions. And by the way, that you know, that relates directly to the other argument that we have. But anyway.
Let's turn to that. Go ahead. But anyway, go ahead.
Yeah, well, I'll get to that. So, yeah, no, it was a strong case for the Commonwealth. I won't belabor it, but there's a lot of, I'm sorry, it's not, I said it's a fairly strong case for the Commonwealth. Yeah, so she sort of, the defendant sort of spaces out when the officer asks him to get stuff from the car. You know, he drops it on the ground. The officer says, pick it up. He doesn't respond, says, pick it up again. You know, follow directions. And then throughout the test, he's not following directions. You know, the heel to toe, he's starting before he's supposed to, you know, start. The one-legged stand. The heel to toe, he even walks 18 paces up and hits the cruiser. He keeps going. Then he walks 14 paces back instead of the 9 that he's told. So, you know, there's that. There's the driving. There's, you know, going all the way from hitting the grass on the right-hand side of the road, all the way over and going over the center line on the left-hand side of the road. You know, fairly dramatic, not the end of the world, but you put it all together, and it certainly it was a pretty decent case.
What time of day was it?
It wasn't late. It was like 12:30, I think. Something. It was, yeah, I think we were around there. Yeah. And all right.
Attorney Kidd, can you discuss? Are you also?
No, I'm also.
Could you discuss the simple direction test of moving the eyes instead of the head in the context of Gerhardt and what the SJC has said about?
Yes, well, yes. And remember,
go ahead. Yeah.
Right. I remember Gerhardt dealt with marijuana, and right. The thrust of Gerhardt was that we can't apply all these alcohol field sobriety tests to these marijuana cases because there's no scientific showing that these
tests... Is it your position that the standardized field sobriety tests have a scientific basis?
Yeah, there is a group of field sobriety tests that have been talked about by NHTSA, I believe NHTSA, as counsel pointed out in a well-written brief, by the way. NHTSA set out these several tests that they believe are reliable, and the nystagmus gaze test is one of them, yes.
Well, he gave the HGN, but it wasn't testified to as an HGN,
no,
fair?
No.
And so we turned it into the directions test.
Yeah.
Follow the pen without moving your head, and then he moved his head. Okay, so my question again is, in the context of Gerhardt, are we turning that into, first of all, is it your position that field sobriety tests, again, the ones that are taken from the manual, the ones that are standardized, are somehow scientific? Do you call it, is it science, is it pseudoscience, is it just common sense? Where is it on that spectrum?
I don't know. Well, the only way I can answer the question is I think that studies have been done, is my understanding, that studies have been done on those particular tests and that there is a correlation between those particular tests and a defendant's coordination, balance, ability to drive, and so forth. So, yeah.
And it didn't happen here, but I suppose in a sense it did. What do we do then when a police officer just makes up their own test, for better or for worse? And sometimes you see it. Sometimes they say, instead of doing the alphabet, start with G and go to P, or go backwards counting, or I mean, none of which are necessarily standardized, but may have the same value or not. But
correct. I know that happens in trials, and able defense counsels ask the officer, you know, is that one of the tests that's a standardized test? No, it's not. So that gets in front of the jury. That should, you know, and as we know these days, I did it for many years on this side. The counsel gets the training book from the training academy, and has all of the training that you know, that the officer had. So.
And do we think that when the prosecutor argues that the officer is training in the special, subtle science of alcohol intoxication, that then it's imbuing these tests with some level of scientific basis that doesn't really exist?
Again, it was a very brief comment. Sure, I mean, yeah, it was. I mean,
so that particular phrase, perhaps better not uttered.
Perhaps, you know, perhaps. But, you know, you look at that, again, in the context of the argument. When he actually got to the tests, as I said in my brief, the prosecutor, you know, went through 5 different factors that he wanted the jury to consider. One of those factors was the field sobriety test as a whole. And then when mentioning this test, or this, whatever you
Since
want
we
to call
appear to be knocking the prosecutor, actually it's a pretty effective argument, the way he laid it out there with he really did. Nice job in that sense.
So let me ask you this. At the end of the day, we have a case that you characterize as not the strongest case in the world. We have a statement that would have better been unsaid with respect to the characterization of the field sobriety test. We have a statement that would have been better left unsaid with respect to the missing witness. So what are we supposed to do with all that?
I think you need to look at it in the entire context of the trial. Going back to these field sobriety tests, it was a very minor part of the.
But collectively.
Those two get together don't equal reversal in my mind in these particular facts and these particular circumstances. You have a police officer, the jury was all instructed on both of these issues. They were instructed with respect to the missing witness that the burden of proof always rests with the government, that the defendant need not testify. There was an opportunity for the counsel to weigh in. Counsel herself did not, I don't think, believe it was a big deal. We have that. We have, in this particular case, the jury, in the second issue, the field sobriety test.
Can we cite that you don't think it was a big deal?
I'm sorry?
Can we cite that you don't think it was a big deal?
Maybe my bad choice of words. All I thought was, I read between the lines that defense counsel may not have thought it that serious. As far as instructions, the jury was instructed on a field sobriety test. They were instructed that field sobriety tests are one piece of evidence. They don't need to be followed, and so on and so forth. The officer, when he testified to this simple directions test, never imbued it with any scientific reliability. The prosecutor never imbued that test with any scientific reliability. The officer, when he was asked why he thought the defendant was under the influence, listed a number of things. One of those was the field sobriety tests themselves. No, that was it. So the jury got the idea that this particular test was one of a battery of tests, which was a piece of the overall evidence of intoxication. So in the scheme of things, no, I don't think that this made a difference, and that's the question we're asking. And I am always a big fan of stopping talking when less is more, I guess, is what I should say. But if there are any more questions, I'm certainly here to answer.
Well, just that you say you don't think it made a difference, but under the analysis of the error in the closing argument, and just grant us that there was an error, burden-shifting error, for purpose of the questions. We consider factors whether there was an objection, the judge's instruction, but the cases cite whether the error could have influenced the jury. And I could see where a statement, where's the state trooper? Notably, we didn't hear from the state trooper. I could see where a jury might consider that. And when they say, well, you know, the trooper didn't even testify on his behalf, would that influence their verdict?
Well,
And did the judges, what I would called fine or standard model instructions, did they suffice to rectify that burden shifting statement?
I'm sort of reiterating my last answer. I think the answer is no for the reasons I stated. I think that in the overall course, if we assume it was error, and I say it was not, I say the judge exercised her discretion because, she was a range of reasonable alternatives, and this was one of them. It was a minor misstep. I say that counsel recognized it as such. Counsel didn't press the issue, and that the jury instructions cured any issue. I don't think it made any difference. No, that's my. Yeah. So I'm sorry, if there are no further questions, I will rest on my brief, as we say. Thank you.
Thank you. Hearing none, the matter is submitted. Thank you both. Very well done on both sides.
Thank you.
Our next matter is docket 23P1156, Commonwealth versus Dwayne Miller. Attorney Peterson for Mr. Miller. Good morning.
Good morning, Your Honors. May it please the Court, my name is Attorney Kim Peterson. I represent the appellant in this case. First, I'd like to start off by saying this is not a pipe. This is not a pipe was an artist's rendition by a surrealist done in 1929 named Rene Magritte. And he did this pipe, which almost looks like a Sherlock Holmes pipe. And he wrote across, "This is not a pipe." And he said, well, all my friends wanted me to write, "This is a pipe," because it was a picture of a pipe. And he said, but I can't put tobacco in it and smoke it. I would suggest to Your Honors, exhibit number 1, this is not a video. And exhibit number 2, this is not a still of that video. And that's what this case is surrounded by. It's about the authenticity of the evidence that was presented at the violation of probation hearing for Mr. Miller.
Okay, so first of all, it's a violation of a probation hearing.
That's correct.
So the standard evidentiary rules don't apply. You agree with that as a premise?
Some do apply, Your Honor. The rules of authenticity of the evidence, as well as hearsay rules. It is a lower standard, but the defendant is still protected by Massachusetts Bill of Rights, the U.S. Constitution Bill of Rights, and all the Due Process Clause Bill of Rights.
We agree it's a lower standard.
I agree it's a lower standard, but it is a standard of preponderance of evidence. It's not a standard of assumption and speculation, which is what this comes down to.
Why is it an assumption when a witness testifies to a fact and a judge credits the witness's testimony?
Because the judge credits the testimony of this witness on these two pieces of paper, on these two printouts that were given.
Yep.
These were not validated in any way except by the testimony of AG, who we will call, for the sake of...
Wait, well, except for. That's kind of a big except for, it seems to me.
There's nothing to authenticate these, in fact, documents. The only authentication...
Okay, hold that thought for a second. When you say there's nothing to authenticate them, you have an email address, right?
That's correct.
And that's the same email address that your client used to communicate with his probation officer?
That's correct.
Same email address that your client used to communicate with the victim?
That's correct.
And the information in there, at least in part, was something that the judge found, at the very least, was information that would have been likely only known to these two people.
That's correct.
How does that not get us under Hartfield, under Purdy, under any one of the cases after that, to a place where the judge, at least in her discretion, could accept that as sufficient to authenticate?
Without conceding that point, Your Honor, and I understand that as a tough nut for me to crack,
Okay.
the problem is that doesn't get us, even if we say that is all true and this is a video, this is a email,
Yep.
that icon is not a video. It is merely an icon. And anyone who has dealt with the computers, if you receive something and it won't open, you don't have that icon. This icon and what it represents is that. It is a video that says...
But then the judge took other information, which was that, again, according to the victim, she got subsequent communications saying, oh, we saw your excellent video. Love to hire you in our next porn film. And the judge inferred from that that's what that icon was. Why was the judge not permitted, at least in her discretion, to do so?
For two reasons, under the authenticity and under hearsay. Number one, we have no idea if those people were real. I mean, one guy had the name Craven Moorhead. Clearly that was a lewd and bogus name. We have no idea who he is, where he is. No one ever contacted him, if he actually saw a tape and if he actually saw that tape, which the defendant is accused of disseminating. Same thing for Shall Life 401. We have absolutely no idea who he is,
So
if he
can
really
I stop
exists.
you? Because that just occurs to me, and I'm just going to lose it. Is it your position then, though, that if the defendant, if the testimony was the defendant said, I'm going to post the video of us engaged in these sexual acts, I have just posted that video. That video is now playing across the internet. That you actually need for the judge to see the video?
No,
For there to be a violation by a preponderance of the evidence?
You need something else,
Okay.
because it says a tape and it calls it something else. It doesn't call it a video. But what it doesn't do is it doesn't even give a description of that video. It doesn't say,
But what
hey,
more do we need? I'm going to interrupt you now for a second, because we do have him saying, I mean, he's clearly upset. I mean, you agree, if we put things in context, he's angry with her.
without consenting that that is actually from him, yes, I would agree that is a response of an angry person in that email.
Okay. And that angry person who the victim put the nature of their relationship into context as to why he might be angry with her, says, I'm going to put it on blast. I've got the videos and I'm going to put it on blast. And then shortly thereafter, that's exactly what happens.
But isn't that, in my opinion, Your Honor, would be speculation and assumption, because there's nothing else tying it until, if I say I'm going to go outside and run around in circles,
Just the irony of it.
it's the irony, right? But that is not preponderance of an evidence, and I know it's a really low standard,
Reasonable minds might differ.
but, you know, reasonable minds may differ, but this is a judge in a position who had a standard to uphold, and that is the issue. And even this explicit video, AG never describes that video. When she is on the stand, she never does. She says the second one is a still of the video.
Of her giving oral sex, right?
No, that's incorrect, Your Honor.
How do I know that?
The still of the video in number 2, supposedly, is her with the defendant's penis, or a
in
male
her hand,
penis
in her
in her hand, right? The only indication we get of what's on that video, what actually is on the video, which is oral sex, is from the East Providence Police Department. That is the only idea that we know.
What's wrong with that?
That becomes
If
hearsay.
the police officer in East Providence said, I viewed it and this is what's on it, and then again, you go through the Hartfield analysis, which, again, the judge in this case clearly did both orally and in writing, what's missing?
It's missing is that's hearsay. Why the probation officer...
If it's reliable hearsay,
But
which
it's not
again...
reliable. It's not reliable
Right.
hearsay because
Or
we have
substantially
no...
reliable, I should say. So, hang on. So, hang on. At least as far as the police officer in East Providence, according to the judge's findings, it was based on personal knowledge and direct observation. In other words, the officer saw it, saw what was we wrote about in the report. I don't know if it was a he or she, wrote about in the report, that the writing of the report was in relatively close time to when the observation was made, that it was provided under circumstances that supported the veracity of the source. The judge found that it was factually detailed. So what's missing, again, you agree we don't need every single one of the Hartfield factors in order for something to be substantially reliable, right?
That's correct, Your Honor.
Okay, so what's missing here?
You're missing the part where the complaining witness just says it's an explicit video. She brings all that information to East Providence Police Department. They do absolutely zero investigative work. They look
Take
at...
her out of it. Say that all the judge had to work with was the affidavit, sworn affidavit in support of the restraining order, and the police reports. It seems to me that a judge just on the documents could find hearsay was substantially reliable, and without even the victim testifying, again, if you apply the law, that the hearsay was, I mean, hearsay is admissible regardless, but at least the violation can be found based on the substantially reliable hearsay.
Well, if you take the victim out altogether, Your Honor.
Her testimony, I mean.
Her testimony. Now it becomes hearsay on the affidavit and hearsay on the police report, correct?
Right.
And the hearsay on the police report
It's
is...
probably 99% of the probation violations that happen in the district court and the BMC every day.
That's right, correct. But I think what complicates it, quite frankly, is that the victim testified, that the probation officer didn't just bring in the police officer and say, look, this is all the information we have. I think, and believe me, doing this case, it has become layer and layer, and as my sister discussed, it's like a Russian stacking doll. This case has become what connects to what for the judge to find this. The police report becomes a regurgitation of what the victim has told him. That is all it is. They have done absolutely zero independent work. They have not tried to contact the defendant through that same email. So they don't know if he can use it somewhere else or someone else has access to it. They do not know the CM character. They tried to contact him once with negative results. The phone numbers that they have for Mr. Miller, none of them work. And then we get the Facebook, which is a completely all new can of worms, because that's inherently unreliable. With the pictures, with her name, with what date it was created, we have absolutely no idea where that comes from. So Justice Hinkle in the district court gets all this stuff and makes it into a web of things. And again, this is not a video. This is a smudge. The police officer down in East Providence never even said, I saw a still, and this is what that was on the still. Because what's on the video is completely different to what the victim testifies is on the still.
What does the police officer say that he saw?
No, not the still.
What
On the
does
video,
he say that he saw?
it said it saw who he identified as AG performing oral sex on a male. That's all he says. But he doesn't follow that up with, I tried to email this address and it came back to me, or anything.
These are the lives of human beings. The judge was not supposed to just kind of check her common sense and life experience at the door and kind of parse out each little thing. She looks at this collectively, right? Is that how we approach these probation violation hearings?
Absolutely. But we're still held to a standard of preponderance of evidence. And we can't go on, well, I assume it's
And the preponderance
this.
of the evidence is certainly less than beyond a reasonable doubt.
Oh, it's terribly low. It's terribly low standard, but it's still not assumption and speculation. And just said, I say I'm going to write an email, doesn't mean I actually do it. And I say I'm going to threaten someone to post something, doesn't mean I'm going to do it.
You're going to write it, doesn't mean you actually do it. And then I get one 10 minutes later, I can't infer that you did?
No, you can't. Not without some sort of proof, not without some give and take. I mean, the defendant still has basic rights, you know what I mean, and basic due process. And I understand district courts are busy. I was a trial attorney for many years, and now I'm a defense attorney, and I understand they're busy.
You're not suggesting that this finding here was a function of an overly busy judge who didn't have time to make detailed and well, I'll just leave it at detailed findings.
Yeah, no, I would never say that because I got to go before Justice Hinkle again probably next week. So I will not
No, she's
say
retiring,
that.
I think, today, so probably not.
So I will not say that. But I am saying, district courts run in a different method than this. I mean, I have spent hours and days looking over this, as my sister has. And it's easy for us to take a back seat and then look at this in a different way. But that's why we have the appeals court, because then we can sit here and we can parse out what standard should have been done. And Justice Hinkle is a good judge. I mean, I'm not going to say she is not. She is very thorough. But I think on this, the probation officer didn't give her enough.
Did she consider all of these arguments?
Your Honor, I don't think she did. The defense attorney did not object enough, in my opinion. And that's why we only have that higher standard on the first email, which the video was allegedly attached to, and the rest of them are just substantial risk of miscarriage of justice. If I was the defense attorney, I would have argued much more. But again, it's Monday morning quarterbacking, in my opinion.
And there's no claim of an ineffective assistance, right?
I'm sorry, Your Honor?
There's no claim of ineffective assistance.
No, I don't think so, Your Honor. Nor did I make one below. I did not believe that this should have been that. It's such a low standard, quite frankly, I did not think. But I do think the defense attorney should have argued more. I think more should have been done to connect the dots and to show this judge what it wasn't, that the video, as the victim just says it, this is the video. This is a video of an explicit on page 9. That's it, it's explicit. And then she says the still is something that the police officer doesn't testify is on the video.
So is there more to the theory other than they didn't prove it, or is it she's manipulating the system, the victim's manipulating the system and sending these things to herself? Or is it just ironic that the floodgates of the social media stuff happened to come right after he announced that he was going to do just that? I mean, where are we with that?
Judge, I don't think I have to argue that. I don't think I have to answer that, quite frankly. You know, I'm not going to, I've been in district courts for a long time. A lot of crazy stuff happens in district court.
Listen, I was a BMC judge for a long time. I mean, I full well know what happens in district court.
So, that stuff I'm not going to get into, because I don't think that's relevant to this argument. I think it's a preponderance of the evidence standard, and I don't think it was met here, Your Honor, and I would respectfully ask that this be reversed. And if you have no further questions?
Hearing none, thank you very much. Ms. Horn, Attorney Horn.
Good morning, Your Honor. May it please the Court, Megan Horn, Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. The hearing judge did not abuse her discretion in revoking the defendant's probation for 2 reasons. She properly found that the 3 emails and the Facebook profile containing explicit material of the victim, which only the defendant had access to, as well as the Instagram direct message and the text messages establishing that the defendant had distributed this explicit material, were properly authenticated. And she also properly relied on both non-hearsay and substantially reliable hearsay evidence that was reinforced by the testimony of the victim. And starting with that authentication.
What explicit material are we referring to? Because I've heard there is none to be seen.
There were 2 items of explicit material, but only one appeared in the record. That was the still of the victim that appeared on the Facebook profile that depicted the victim holding the defendant's penis.
And in that still, at least the version that I had, can you make out what's going on in that still? I mean, can you see who's who in there?
It's admittedly difficult to decipher, but I can see that she does appear to be holding the defendant's penis, and the judge actually herself made findings that she also admitted it was difficult to see, but she made findings that the victim did appear to be holding a penis in the image. Starting with that authentication point, though, I won't spend too much time on the 3 emails. Those are very clear that those have been sufficiently authenticated, as those came from the defendant's email address. The victim testified that she had communicated with the defendant at that email address, and there were emails between the probation officer and the defendant at that email address that were introduced alongside it. Further, per the victim's testimony, that first email and the second email contained explicit material that she observed when she received it.
What about the Instagram DM and the Twitter, now X, message? What do we do with those?
Yes, moving on to those, I believe that it was an Instagram direct messages and actually text messages that she had received. And the point of those isn't that she had received them from any specific person, but rather that there's circumstantial evidence that the defendant had distributed this explicit material. So really who sent them to her is besides the point. She had testified that she didn't know who sent them. Bring this back to the standard. The standard for authentication is that the item is, by preponderance of the evidence, what the proponent claims it to be. And here the proponent is simply Here the proponent is simply claiming these to be messages received by the defendant from someone claiming that they had seen this explicit material of her. And for that purpose, the timing and the content of the messages is sufficient to authenticate them. Moving on to the Facebook profile, I know my sister had raised several arguments as to this Facebook profile. Again, the Facebook profile contained multiple images of the victim. Bringing it back to that still, the victim had testified that only the defendant had access to that explicit still of the victim. And further, there was an image of the victim taken from a FaceTime call that only the defendant and the victim were on.
So let me ask you the same question. that I asked Attorney Peterson, which is take the victim's testimony out of it completely. And all you have then is the East Providence police report, the affidavit in support of the restraining order, the criminal complaint that issued in East Providence, just the documents. Would that have been enough for the judge to have found by a preponderance of the evidence that the defendant violated his probation?
Yes, that's certainly enough. Consider what's actually in the report.
Now tell me why.
So what's in the reports is the officer here spoke to the victim, got the information from the victim that she had received these threats from the defendant, threatening to release the video. She actually showed the officer the first email and the attached video. The officer viewed the video himself. He put in the report that it was the victim depicting oral sex on a man. She also told the officer that she had received these messages from someone she didn't know, claiming to have seen the video. I believe this was specifically in reference to the text messages. And then she later came in and told the officer about the Facebook page when she had made the discovery. That on its own would be sufficient to revoke the defendant's probation, even if the victim had not testified. But here she did. There's no doubt that this is sufficient to revoke the defendant's probation.
Defendant testified too, right?
The defendant did testify as well.
Okay. But as I recall it, Judge Hinkle discredited him, or implicitly at least didn't credit his testimony. Is that fair?
She did not make any explicit findings as to the defendant's testimony, but she implicitly did not credit his testimony. He largely testified that he had given his credentials to the victim. He didn't know about any of this. He implicitly did not credit it. I did just want to touch a little bit on many of these hearsay points. I think the most important point here is that hearsay is admissible at these hearings. It's really an issue of whether the hearsay is substantially reliable enough to be relied on by the judge. And here, all of the hearsay is substantially reliable enough for the purposes of this hearing. Certainly, I've already made reference to the police reports and the sheer amount of detail depicted in those. But again, moving on to even the Instagram direct messages and the text messages, their timing and their content and the surrounding corroboration by the facts, that is enough to make them substantially reliable for the purposes of this hearing. Or the Facebook profile, where again, it appeared within the pertinent time. It's reinforced by the victim's testimony from her personal knowledge. She saw this Facebook profile. It contained these images of her. It's worked into this web of corroboration. It's sufficiently reliable for the judge to rely on it for the purposes of this hearing.
Was there anything to which defense counsel objected? Just trying to remember, any of the documents, anything at all? Was there? I'm trying to remember reading through the transcript whether there was even an objection period. Maybe
Hearing counsel only objected to the first email that the victim testified contained the video, and he only objected to it on authentication grounds.
Okay.
He didn't object to any of the other documentary evidence. And just for the purposes of the 3 emails, those actually aren't hearsay. That would, again, pursuant to our discussion of authentication, those are statements of a party opponent. The actual body of the email, as they've been authenticated as having been sent by the defendant, those would be statements of the defendant and not hearsay at all. I know my sister has raised arguments as to the icon depicting the video itself, but besides the point, the victim has testified that she observed the video attached to the email with her own eyes, and the judge has credited her testimony for that purpose, and her testimony generally. So certainly there is no doubt that the evidence is both sufficiently reliable and sufficient to revoke the defendant's probation. And if there are no more questions, I would rest on my brief.
Hearing none, the matter stands submitted. Thank you both very much.
Thank you.
next matter on our docket is 23P0718, Commonwealth versus Lujan? Mr. Levin?
Morning.
Just give me a moment to tee it up.
Good morning, Your Honors.
Morning.
May it please the Court. Patrick Levin on behalf of Mikhail Luzhin. This case concerns the admissibility under Massachusetts common law and the state and federal confrontation clauses of testimony by forensic analysts at the State Police Crime Lab regarding tests that they did not personally conduct. There's two analysts at issue in the case. It's a criminalist and a DNA analyst. I'd like to begin with the DNA testimony because I think that the course of that testimony really helps to illustrate the difference between the permissible and the impermissible testimony in this case. So Ms. Gould, the DNA analyst, testified to a comparison she did between two DNA profiles and offered her opinion that the two profiles matched each other. That is an admissible expert opinion, and the defense counsel did not object to it.
So far, so good.
So far, so good. Now, the reason that that opinion is so significant to the case is where did those two profiles come from? And so the Commonwealth presented evidence that one comes from the defendant's saliva sample and one comes from the vaginal swabs in the alleged victim's rape kit. As to the defendant's saliva sample, we have live testimony from a police officer that he collected the sample. Then we have a stipulation that the sample was then brought to the crime lab and that DNA analyst Kim Bonner developed the DNA profile from that sample. As to the rape kit, we have live testimony from the nurse concerning the examination that she conducted, that she collects 5 sets of swabs, including the vaginal swabs as well as most relevant here, an external genital swab. Then we have a stipulation that the rape kit is brought to the State Police Crime Lab, and that we have the case jacket from the crime lab is also stipulated to, which shows that the criminalistics unit receives all 5 swabs and forwards 3 of the swabs, including both the vaginal swab and the external genital swab, to the DNA unit for analysis.
That's all part of the stipulation.
That's all part of the stipulation. At that point, we have a lacuna in the admissible evidence. Because Ms. Gould did not develop the DNA sample, she has no personal knowledge of which of those 2 swabs it was generated from.
Except that they're marked, they're labeled, right?
So the swabs are labeled, but Ms. Gould has no personal knowledge of which of the 2 swabs the DNA sample referenced in Kim Bonner's report was generated from. Her only knowledge of that fact comes from the report that says, I developed this from the vaginal swab, and references that label number.
So is it your position then, Attorney Levin, that in this case, effectively, it would have been impossible for a substitute chemist to have properly testified as to the DNA results?
So she could
Think of a different way to do it.
So she could testify as to the DNA results.
Right.
We have sufficient evidence to prove that Mr. Luzhin's DNA was found in the rape kit. So I think there's sufficient evidence on the indecent assault and battery charge here. We don't have sufficient evidence about whether it came from the vaginal swab or the external genital swab. So it's sufficient admissible evidence. Now, there is sufficient evidence because Ms. Gould does, in fact, testify that Ms. Bonner developed the profile from the vaginal swab.
Without objection, right?
No.
Okay.
Over
That one, there was
objection.
an objection to that one? All right. There.
So
Yep, let me find that.
I want to be clear about what the objections were.
Right.
So the course of, you have to look at the whole course of the proceedings to really understand the objections to the DNA testimony. So during the pretrial arguments on the motion in lim, so the Commonwealth files a motion in limine to admit the substitute analysts. The motion calls the judge's attention to the relevant case law. And then defense counsel notes, these reports are testimonial hearsay. I don't know that I can object to Ms. Gould being called to testify. And of course he can't, because the case is made clear. She's allowed to testify about her opinion. But he says, what he says about the DNA analyst in particular is essentially that I don't want to concede up front that she is a proper witness, because until I try to cross-examine her, I don't know whether she will have sufficient knowledge under the SJC's cases, Greineder, Tassone, to be able to testify about the lab's, evidence handling, et cetera. That's essentially the thrust of what he says, but that, if she can come up and only knows the answers to the Commonwealth's questions and not to mine, then that's going to be a problem.
Do you think at the end of the day she was the person to call pursuant to Greineder?
So she was...
Had the authority and the oversight to do that?
She was a proper witness to call in this case in terms of her opinion.
Okay.
Yes. So under Greineder and under Tassone, you do need to have a witness. In order for the opinion to be admissible, you need to have a witness who knows about the particular crime lab at issue, and she does. So her opinion is admissible, again.
And this is Gould you're referring to?
Ms. Gould, yes.
Oh, Gould.
Ms. Gould, yes. So then, during the criminalist testimony, there's some objections during the course of the direct testimony, and then at the end of the testimony, he moves to strike. So I'm not going to argue right this second about the motion to strike, except to note that at the end of it, he says, what we have here is the exact same problem as in Melendez-Diaz. The only difference is, instead of introducing a piece of paper that has this testimonial hearsay on it, we're calling a witness to testify to it out loud. So now you have this Melendez-Diaz objection. Then Ms. Gould is the next witness. And at page 154 of the transcript, the prosecutor elicits that she's reviewed the file, she's reviewed Ms. Bonner's work, and he asks, do you have an opinion as to whether or not a profile is developed from the vaginal swabs? He asks for that opinion. At that point, defense counsel says, I object. It's the same objection as with the last witness. So that's the Melendez-Diaz objection.
Okay.
The judge overrules the objection. She continues to testify, and at the point where he asks her, okay, so you compared the vaginal swab profile to Mr. Illusion's known sample, there's another objection. At that point, the prosecutor reminds defense counsel that they had stipulated to the known sample. Defense counsel withdraws that objection. And so he elicits a few more questions worth of foundation about how does the comparison work. And then he asks for the actual opinion regarding the comparison between the two swabs, and defense counsel says, at this point, I'm going to renew my objection about the vaginal swab sample.
So let me circle back to my question from a few minutes ago, which is, what is missing here from your perspective? And under these circumstances, again, how could the Commonwealth find anyone, assuming that the chemist who did the test was literally not available?
Right.
How could you ever find a substitute chemist or a substitute witness to testify?
So,
what else could they have
so
done?
I don't know for sure the answer to that, because there's not a lot of detail elicited about what the evidence handling protocols at the lab actually are. You could imagine a situation where the way that they handle the evidence is such that each swab really is, goes along its own separate track and has a completely different report associated with it, et cetera, et cetera. We don't have any testimony like that here. And so all we have is Ms. Bonner receives all three samples, produces some kind of reports that Ms. Gould says she's reviewed. And then Ms. Gould is allowed to testify. The sample that this profile comes from is the vaginal swab sample. That's not allowed. Now, I want to compare this testimony to the testimony at issue in Williams versus Illinois.
So far, everything that you said, was that put before the jury?
I'm sorry?
So far, everything that you've articulated to us about the the strength of the materials, and that we can't be certain that this is where they actually did come from. Was all that before the jury?
So it's a bench trial, Your Honor.
All that before the judge?
But it's all before the judge. So in Williams versus Illinois, what we have is identical testimony. There's a testifying analyst who and there's, she personally developed the known sample in that case, and then the other sample is sent to Cellmark. We have evidence in the record in Williams of the shipping manifests that's admitted as business records that shows the vaginal samples are mailed to the lab, and then the lab sends back the samples along with their report. And the witness testifies, I compared the known sample that I developed to the samples that Cellmark developed from the victim's vaginal swabs. That's the testimony that's at issue, and it's identical to the testimony in this case. Now, in one respect, it is distinguishable, which is that here, because the reports at issue, all the analysis at issue, was done at the State Police Crime Lab after Mr. Lujan is indicted for the purpose of producing evidence to prosecute him. The reports are testimonial even under Justice Alito's test. So that's the only respect in which this is distinguishable from Williams. Now, if you look at Commonwealth versus Greinader, which is a case out of the SJC that was remanded for reconsideration in light of Williams versus Illinois, what the SJC says in Greinader is the testimony that was at issue in Williams clearly would have been inadmissible under our common law. That disposes of this issue. It's the same exact testimony. It's inadmissible under our common law because—
That's footnote 15 you're referring to in Greinader, right?
So it's in several places in Greinader. The clearest articulation of it is at page 592. The expert witness's testimony in Williams that implicated the DNA test results of a non-testifying analyst would have been improper under longstanding Massachusetts law. And so that's, in my view, that's the beginning and the end of this case on the merits of whether this witness is allowed to testify about how the DNA profile was derived, given that she did not do it herself or witness it being done. The Commonwealth's brief cites to a number of Massachusetts cases in which superficially similar testimony appears to be endorsed. The issue in all of those cases was the admissibility of the expert's opinion. In none of those cases did the defendant challenge the type of testimony that's at issue here. The question there in all of these cases is this expert allowed to testify to her own independent opinion about this evidence, and can that expert be adequately cross-examined about that opinion? But here that's not the issue.
So if the judge simply took the opinion, so if we didn't have any of the,
Right.
usually that's how it's supposed to go.
Yeah.
And we assume that the judge instructed himself properly to disregard anything that should not be considering, then why could not just the opinion stand on its own, and why does that not get the Commonwealth where they need to be?
Well, we know that the judge didn't instruct himself correctly because he overruled all the objections to the inadmissible testimony.
Fair point. All right.
And then, of course, at the end of the case, he expressly refuses to consider the lesser included offense of indecent assault and battery, which if he realizes I don't have any admissible substantive evidence before me of whether this DNA match comes from the external genital or the vaginal swab, he would have to consider the indecent assault and battery charge. In fact, he would only be able to convict on the indecent assault and battery charge.
But it would have been proper if the witness was simply asked, based on your review of the documents and given the hypothetical, do you have an opinion as to, and then the witness gave the opinion. right?
That's-
And then the question would be, well, you didn't get a lot of the foundational specifics, so it goes to the weight as opposed to the admissibility of that particular opinion, correct?
Right, and so the judge repeatedly uses this language of that goes to weight and not admissibility. But in the course of saying that, what he's doing is overruling the objections to the inadmissible portions of the testimony. So we know he doesn't actually understand the way in which, what we mean when we're talking about this kind of evidence and how it only goes to the weight. It goes to the weight of the opinion, but the way in which it goes to the weight of the opinion is that the opinion is not very weighty if there's no other testimony admitted besides the opinion. And that's all that's admissible, of course. And that's clear under the cases. I see that my time has expired, so if there are no further questions from the bench.
I do have some further questions about the analyst Waite's testimony.
Yes, Your Honor.
In the Commonwealth, well, we'll actually start from the beginning. From my reading of the transcript, she seemed to initially just confirm what the prior analyst had done.
She's literally testifying based on my review of Ms. Cronin's report. It appears to me that she followed all of the proper lab protocols and she conducted this screening test properly on the vaginal swabs and that the result of the test is positive. That's her testimony. This is straightforwardly inadmissible under Bullcoming versus New Mexico.
They conclude, though, and we'll hear from the Commonwealth in a moment, with her testimony about the card, that she independently reviewed the card.
Right.
And she can form an opinion based on her review of that card, an independent opinion. How do you respond to that?
So what I say is that that's not an admissible expert opinion because it doesn't require an independent exercise of judgment and expertise. That what they should have done, perhaps, is actually bring in the card and mark it as an exhibit and put it in front of the fact finder. The fact finder can look at it and see if there's one line or two lines on it.
Similar to an analysis of the weight and the
Exactly,
the
in
weight.
cases like Munoz and Grady.
But then they need an explanation as to what one line versus two line means.
Sure, we need that explanation, but once we have that explanation, she doesn't have any expert testimony to offer.
Other than the meaning of one
Right.
line versus two line in the context of a.
Exactly, and she also testifies that that various other substances cause the positive result. She has no idea what the false net positive rate is of the test, et cetera. But the ultimate conclusion that she gives based on her viewing of the card is not an admissible expert opinion. We ask that you reverse Mr. Lujan's conviction and remand for a new trial at which he's able to confront the witnesses against him. Thank you.
Thank you. Mr. Joyce, Attorney Joyce.
Good morning, Your Honors. May it please the Court. ADA William Joyce on behalf of the Commonwealth. Before I begin, I'd just like to briefly acknowledge the family of the victim who is observing the proceedings via the live stream. The victim herself passed away before trial. I'd like to begin, Justice Smith, with your point about the distinction of Ms. Waite's testimony. There's really sort of almost a bifurcation of her ability to testify. One is as a direct eyewitness. She physically saw the results of this card, and just like any other eyewitness, she can go up on the stand and say, I saw this card, it had this result. Her expert opinion comes in through the explanation of, here's how this test works, here's how you interpret it, but also her later review, independent review of the original analyst's findings. While the phrasing of her testimony might have been a little bit less than ideal, this was a bench trial. The judge is presumed to be able to sort out inadmissible testimony. But I would also proffer that her testimony is not just confirming the original analyst's results. It's saying, I reviewed her findings, I reviewed her procedure, her report, and I find that this is a valid result. That this conclusion matches what I saw on that card. That's what her expert testimony is.
Well, the question posed on page 133, the trial transcript one, is based on your view of the file, do you know if there was a screening test done on the vaginal swabs? Answer, yes, there was. And based on your review of the file, what was the result of that? There was an objection, same objection as before. Overruled, that was positive. You're saying that's an independent opinion?
I'm saying that later on, I forget the exact page, she did say that she physically saw the result of the card herself.
But what I just read, that's not an independent opinion. Or do you think it is an independent opinion? That immediately precedes the portion about the card. It's the page prior.
I don't think, again, the question could have perhaps been more artfully better rephrased, but I don't think that's much different from asking, say, a DNA analyst, based on your review of the development of this profile, what is your opinion as to whether or not it matches this other profile? I think they are analogous. Again, because it's a different type of test, it's a little bit harder to parse where the line is. But given that she physically saw the results herself, she saw the card, I'd say that under the circumstances, any error that may have existed is trivial.
So your position is that Attorney Levin's suggestion that they bring the card in and show it could have done it, but it wasn't necessary?
Correct.
Is that what I'm hearing you saying?
Also, there are public policy reasons to not bring in a biological sample unnecessarily. There's also logistical issues of then the clerk's office has to store it and maintain that.
You say unnecessarily unless you're sitting in the defendant's seat, right? I mean, they want the surest proof.
The defendant could have also asked for the card to be brought in and introduced. That is also a possibility. If there was some sort of chain of custody issue, the prosecutor might have felt, okay, we need to bring the card in and we need to show it to the judge. But this wasn't really a contested issue that this test occurred, I suppose. Moving on to Kathleen Gould's testimony. Case law, and I'm referring more specifically to Grinder and Banville, suggests that a substitute analyst, part of the reason they are allowed to testify as a substitute analyst is that they are familiar with the policies, procedures of the specific lab that conducted the testing. Both Waite and Gould were analysts at the same lab as the original analyst here. That's distinct from the situation in, say, Williams or Commonwealth v. Tassone, where this was analysis done by an outside lab, Cellmark in both situations, and no one from Cellmark came in to testify, here's what we did, here's how we developed this profile. It was simply the analyst from a different lab saying, yeah, I reviewed those results, I don't know how they generated those results at all, but I'm taking them at face value.
So here we have the proper witness.
Correct.
Okay.
And I don't think there really is any contest about that. The distinction is then, so what is the limits of their ability to testify? And Grinder and Banville's basically give a framework, more or less paraphrasing here, say that based upon their training and experience, development of a DNA profile from a particular exhibit, and a review of a DNA profile from the defendant developed by a non-testifying expert, the probability of that DNA in question belonging to someone else other than the defendant was 1 in X. Now, no case has actually basically outlined why this is acceptable. It's sort of, you have to build a patchwork from other cases. And what it seems to be is the opinion that this profile from a specific piece of evidence matches the profile from the defendant is an opinion. It's with an unstated assumption that the profile from, as relevant in this case, the profile from that specific piece of evidence was actually derived from the swab of that evidence. So what do we...
You're talking about the vaginal swab.
Correct.
Specifically, yeah?
Correct. It's an unstated assumption that that swab was actually the swab that was tested. How does the analyst know that? Well, the short answer is she doesn't. She didn't do the testing. She has no way to know. She's just relying on the notes and lab policy. And the cases say that's fodder for cross-examination.
And in your position, as I understand it, is that is literally how all of these work.
Correct.
Because the substitute analyst would, again, quite clearly have no way of knowing, because if they were the person who did it, they'd be there and they could testify to what they did or what they saw.
Well, I don't want to say in all cases.
Right,
There may be cases where the analyst does go and they look at the actual item, they look at the actual swab. And again, the best case in a perfect world, we'd go redo the testing and put that analyst on the stand, but we don't live in a perfect world and there are limitations for resources and testing.
But it's often not an issue what's being compared, correct?
It can be.
It wasn't an issue in Williams. There's really no doubt of what the sample was.
I believe so. I'm working a little bit off my memory. The problem is a lot of these cases have very similar details, so keeping them straight in my head is a little difficult.
Well, in this case, though, there were samples that came back negative.
Correct.
The external, correct?
Correct. The
And
external and the oral.
how would, getting back to Justice Brennan's initial question to your brother, how would the Commonwealth, how else could they have established that the swab, the vaginal swab, was positive?
I'm sorry, I missed that last part, Your Honor.
How else could they have established, could the Commonwealth have established that she was comparing the vaginal swab to the profile of the defendant?
The case law says that there is no way for the Commonwealth to establish that on direct. That would be getting into the underlying hearsay of the hearsay underlying the expert's opinion, and the case law says on direct examination, the Commonwealth cannot touch that information.
Isn't that what happened here?
Not exactly. I'm specifically for Gould. I'm referring to.
Okay, I thought that's what happened here in Gould, with Gould. That she, on her own, took the, is it Bonner's
Bonner.
determination that the vaginal swab was the item.
She took the profile derived from that sample and compared it to the profile derived from the defendant's sample and concluded that they were a match. What she took as an assumption was that the sample that Bonner tested and developed a profile from was the vaginal swab.
That's a big piece, though, right?
Correct.
Because he admits that he had some contact with the victim.
Correct. But the case law says there's a way for the defendant to challenge that. First off, he could ask for additional testing, retest the sample, either have the Commonwealth do it or get another lab that he wants and have that tested. Second, he could do a Dalbert-Lanigan hearing, get into the details of what the analyst actually reviewed, parse out, how did you base your assumptions and your conclusions, go through that, determine, is this opinion actually reliable?
So those are the same steps that the Commonwealth could have taken? Who's the burden on here?
I suppose a little column A, a little column B, Your Honor. I think because this was a bench trial, it wasn't really felt to be necessary. But there is a...
It's what you're saying, and again, I don't want to put words in your mouth, that it really wasn't an issue at trial.
Correct.
That was not the issue.
And
that's why
was not a heavily contested
defendant
issue.
didn't raise that, and that's why the Commonwealth didn't feel compelled to go get it retested and spend the resources or expend the resources on this as opposed to the thousands of other cases. Is that the gist of it?
Correct. I will, one moment while I find the exact page, I'll refer you to the pretrial discussion on the motion in limine around page 30 where the defense attorney says...
Page 30 of what?
Volume 1, my apologies, Your Honor.
Say it again, please.
Volume 1, page 30?
Yep.
Where the defense attorney, in reference to Kathleen Gould's expected testimony, says, I think it's testimonial hearsay. I don't know that I have a problem with it unless when I start asking her questions about the other tests that don't have DNA on them, she doesn't know the answer to any of my questions.
So the presumption there is the Commonwealth is going to put it as an opinion, then the defendant has an opportunity to get cut under it if they like and cross-examine, and there's not a problem unless we go there and there's some issue that doesn't appear to be. Is that?
Well, and that's the third method of attacking this is on cross-examination, the defendant can get into the details just the same as the Commonwealth or the defendant could during a Daubert hearing. The only difference is at trial, the Commonwealth cannot reach those details unless the defendant opens the door on cross. And here, the defendant on cross did go into those details with both Waite and Gould. One moment while I... Gould, apologies, Waite, the defendant got the fact that She didn't observe the actual testing, so she doesn't know what swab was actually tested for the screening test. A few other things.
So all that's in front of Judge Hodge?
Correct. And similar with Gould's, got similar testimony in that Gould doesn't know what exactly happened. So given all of that, I don't think in context, all things considered, that there was any sort of violation of the defendant's confrontation rights here. He was able to cross both experts, substitute experts, about the basis of their opinions and attack the credibility of their findings.
The judge's reference to, upon objection to the evidence coming in, that it goes to the weight and not the admissibility. Is that an incorrect legal standard he was citing? And should we presume he knew the law if he was?
I don't want to outright say no, Your Honor, mostly because I think this goes to the Commonwealth's point about whether or not the issue was actually preserved, that the objections that were raised were unclear in context. It seemed like the defense attorney was objecting more on speculation and foundational grounds than any sort of confrontation issue, and which are more chain of custody objections.
Which would then go to the weight of.
Correct, and I think.
Not its admissibility as opposed to confrontation issue.
I think that was Judge Hodge's confusion, is he thought these were issues raised on chain of custody rather than any potential for confrontational. And I think that goes to the point of the objections are unclear, therefore it's hard to say whether or not these issues were properly preserved for appeal. The issues that are now raised, I should say.
So what do we do with that?
I think in context, given everything, there is sufficient grounds for this court to affirm the conviction that there was enough evidence to demonstrate the charges that the defendant was found guilty of, and any error that it existed had no impact on that. I will also note that the defendant has not raised any sort of ineffective assistance claim. There was no motion for a new trial raised below where those claims were made. If there are no further questions, the Commonwealth will rest on its brief.
Thank you both. Nice work. Matter stands submitted. Take a brief recess.
All right, please. Court is now in session. Please be seated.
Thank you. Okay, the next matter on our list is impounded. 23P1204. Attorney Rosenthal.
Good morning, Your Honors. May it please the Court. Steve Rosenthal, representing the appellant mother. The crux of this case is that the court-appointed special advocate, the CASA, wrote on 5 different occasions throughout these proceedings that we have to consider whether this severely disabled, mentally disabled mother requires special accommodations to help her reunify or to at least cope with the tasks that DCF was asking her to fulfill.
All right. So to begin, we're not really taking issue with any of the specific findings of fact or conclusions of law. Is that fair to say? Because I didn't see that in your brief.
Well, what I said in my brief was that I don't argue with the 151 findings of fact, except for a few individual ones, which I mentioned in the brief. The problem is what the judge did not address, the findings of fact that were not made. And it was a fact that this woman, this mother, who was mentally disabled, was a person who the CASA said on numerous occasions, hey, she should be considered for ADA accommodations. And at no point did DCF or the judge say, well, wait a second, maybe we should at least consider, maybe we should have an ADA meeting, maybe we should consult any of the medical specialists who are employed by DCF to determine whether that would be appropriate.
So, and that brings us to, it runs throughout the life of the case because there was really no specific request for that or objection that that wasn't happening. So whether it's preserved or not, I know you're citing a rule.
That's true, you got me there, but
Gave us a Rule 23 case that talks about, it runs through the life of
the
the
May
case.
case that just
so
came
it's
down
preserved.
recently.
Right, I'm not sure that case actually helps you a lot because in that case they affirmed very similar to facts of this case, I'd say. But go ahead.
And I think what really matters is not who asks for the accommodations, but whether DCF has put on notice that accommodations may be required.
What would that accommodation have looked like, ideally, from your perspective?
Well, I addressed those in my brief. Certainly before 2022, there had been requests by the CASA for ADA accommodations.
Yeah, but what specifically? She had the family stabilization services, right?
I'm admitting she didn't.
She was on a conditional custody to begin with, so it wasn't like we just came right in here and or the department came right in and was trying to remove the child or terminate the rights. They were essentially trying to work with mom. Now, you know, your point's not missed. I mean, you have a woman who has severe mental health issues, and then we're faulting her for not acting in a rational way and keeping up with the agreements that she made. And I'm just not sure how you do that. But what could they have done? I mean, this is a woman who was hospitalized for some 4 or 5 weeks and refused to take the medication in the hospital. I mean, so short of strapping her down and giving her medicine, what were they to do?
Well, short of strapping her down, the court clinician made recommendations which included having mother go through a medication evaluation.
But doesn't all of that require mom to agree and to participate in that stuff? But mom, suffering from mental illness, is hyper paranoid, not trusting, does not want to engage, and is not engaging. So what do?
You consult the experts who work for DCF, and you say, how do we deal with a woman like this? It can't be the first time that DCF has faced it.
It's not the first time, I'm sure.
Right. So
But
that's what
the
these
difficulty of mental health.
that's what these consultants are there for, and that
To what
wasn't
extent was
done.
that incumbent on your client's attorney, right? Because she was represented throughout the process.
She was represented by counsel, yes.
Right. And so wouldn't that have been, at least on some level, to whatever extent there was deficiencies in what DCF was suggesting, for her attorney to say, whoa, wait a minute, don't you hear from it's not a GAL, but effectively, don't you hear what they're saying over here? We need to try something different.
I don't know that it was absolutely necessary for her trial counsel to say that. And in fact, when DCF promulgated its own policies during the life of this case, those policies called for DCF to be proactive, to initiate discussions about ADA accommodations.
So they had to either inform the parent of the disability policy, right? And our attorney was aware of the disability policy, fair? Or we don't know that.
I'm sorry, I missed part of what you said.
The attorney was aware of the disability policy, so seems to me we have to presume that the
I would
mother
assume
would be.
so, yes.
Consult with the supervisor, seems like that happened, there was some consultation there, right?
Yes.
Or consult with the department specialist, and that's where you're saying they fell down, that they didn't do the third?
Well, they didn't do, I'm sorry, the first again.
First was inform the parent of the disability policy and explain what an accommodation is.
There's no evidence that that really
That's fair.
happened.
Okay.
The consultation with the supervisor, that's part of an ongoing social worker's job description.
Right.
Every ongoing social worker consults with his or her supervisor.
Well, it may be a bad policy, but if it's in the alternative and they did one of them,
Right,
why do we fault them for that?
But it didn't work, Your Honor.
Right.
The problem is, okay, we'll have our area project manager, or whatever the APM stands for, we'll have them talk about different ways to approach this. No evidence of that.
At what point is it, if ever, appropriate for DCF to say, I don't know what else we can do here. This person is so profoundly mentally ill that really we just don't have the capacity to address this situation, and so we're going to talk to the supervisor, she's got an attorney, we do the best we can, and then, by the way, in the overall picture of the best interest of the child, are we really going to put the child back with this horribly and sadly mentally ill person?
Well, let me take the last point first,
Sure,
which is that mother demonstrated at least a reasonable capacity to interact properly with her child. The problem was, this is a woman who, as a child herself, was a consumer of DCF services. And by the time she was like 26 or so, when this case came up, she had absolutely no faith or confidence or trust in DCF, and DCF would, maybe unintentionally, would nevertheless trigger her. That third option that you and I were just talking about is the one that they didn't pursue, that the judge didn't look at and say, well, gee, maybe we should do that now, at any point along the way.
So, one, I'm not sure it was because she was, I have questions as to whether or not it was because she was a child consumer, although we see these things happen generationally, sadly enough.
I'm not saying that her mental illness was a product of her having been a child in DCF care. What I'm saying is her involvement with DCF from a very, very young age is something that fostered a distrust and an inability or an unwillingness to engage with DCF or its affiliates.
The department would say that this wasn't an issue that was raised earlier in time, giving us an opportunity to respond appropriately. And so I know your argument is, well, it's throughout the life of the case, but what do you point to? When in time do you point to that you say should have put them adequately on notice?
November 2021 was the date of the first CASA report that mentioned, I've met with this woman, here are all the resources that I've consulted, and this woman has a serious problem, and if I can quote, she says, "It is important to note that mother suffers from a disability and struggles with other mental health issues. DCF has reported," and they go through her diagnoses, "this CASA is concerned that mother may need a reasonable accommodation to effectively access services. However, this CASA is worried," and this was very diplomatic on her part, "is worried that the process of determining such accommodation, as well as adherence to other ADA requirements related to a parent with a disability, is not being considered in providing assistance to her."
Was that
Okay.
before or after the ADA policy was promulgated?
The disability policy of
Yeah.
DCF, that was roughly 2 months before. All right, and then, again, two months later, now DCF is saying to their own people, hey, you have to be more proactive about this. So that's, to answer your question, Your Honor, that's where I would say, hey, that puts DCF, and it puts the judge. This is, in effect, the judge's own witness, right? The judge's own expert. That puts the court on notice that there's an issue here, and the judge didn't address it at that time. It didn't.
Not the strongest request, right? I mean, what you just read to me says there's a concern, but not really. I mean, it's not the.
Well, I don't think the CASA is saying not really. And CASA says it 5 different times from November of 2021 until the day the trial began. Said essentially the same thing that I just read to you.
So specifically, what services do you think that they should have had her engage in?
Well, Your Honor, that's above my pay grade. But what I would suggest is that DCF should have consulted with all those experts who are listed in that third option of their disability policy. I forget all the names, but they are all experts in dealing with people with mental health issues. And instead, at least for most of 2022, when, before the case came to trial, her ongoing social worker was, no offense, but a kid who was less than a year out of college. And she said over and over again, I had trouble making sense of what she was saying to me, and she wasn't making sense of what I was saying to her. I spoke to my supervisor, and we didn't really come up with anything. And we finally got Dr. Shelby's report, and we talked about it amongst ourselves, me and my supervisors, but we never really developed anything to respond to it. So what I'm saying here is that the judge failed.
Before you move to that, what do you say about the efforts that the department did make? I mean, you're not sitting here and saying the department made 0 effort.
No, DCF offered services, but with all due respect to DCF, they were the same cookie-cutter services that are offered in any of these cases, and I'm willing to bet that this panel, the judges on this panel, have seen similar, if not the exact same action tasks in dozens, if not hundreds of other cases before this court. So, yes, they offered...
particularized enough for this particular mother.
I missed the first part of what you said.
It wasn't particularized enough.
It wasn't particular. Yes, well, what you said.
I don't want to jump ahead and get you off your rhythm, but we're running short on time.
Yep.
You argued that the judge, we shouldn't give deference to the judge's findings because of the delay. And the department, and I think the child's attorney countered, it seems to me, correctly, that the judge actually issued a decision, as often happens, just didn't do the findings and rulings, specific findings and rulings, until it became more of an issue when the case was appealed. So what's wrong with doing that? And I presume, based on the findings, the judge was taking copious notes, because it appears that there was something, so
the judge...
Right? 30 days after you get the decision is made.
I don't have a problem with that.
Okay.
But mother couldn't appeal her case without knowing what the judge's rationale was. And she didn't know, or I didn't know, what the rationale was for 11 months after the close of evidence.
Yeah, I mean,
No,
we
was
can all
there any
agree with
motion to get them before that? I mean, did they take any acts to try to get them? I mean, we say 11 months after, the rules call for what? Is it
90 days.
So 3 months, so late for sure.
Well, I would first say that I hope you will ask DCF's counsel the
Got some
same
questions for
exact
DCF.
question.
Rest assured.
But in my experience, I find that filing a motion to expedite findings in the district court is frankly a waste of time, because judges will say, we'll do it when we get around to it. And the fact that maybe they're overburdened or they have too many cases, that's a political issue, that's not a legal issue. The legal issue is, what is the rule, and does the rule mean anything?
Well, that sounds like an anecdotal argument to me, so, I mean,
Yeah,
we don't say we don't file a motion because I know what the judge is going to say.
Well, again, as I argued in my brief, and I'm sorry for going over my time, but if that is the issue, if the stability of the child is the overriding issue in this case, then any of the parties should be filing motions to expedite, because certainly DCF is, and the child is hoping that the matter will be resolved sooner rather than later.
For sure. And,
Thank you for your time.
Well, before you step away,
Yes.
given we brought up the best interest of the child, is it your position that it's in the best interest of the child for mom to still have her parental rights?
I'm not asking this court to vacate the judgment and let mom take child home. I'm saying vacate the TPR, send the case back to juvenile court, and allow for review and redetermination after ADA accommodations have been considered.
Your time. Thank you.
Thank you, Your Honors.
Who are we going to hear from first? Counsel for the department or counsel for child?
Good morning, Your Honor. Carol Frizzoli, representing the Department of Children and Families in this case. Again, we start this case off, mother is conceding to unfitness. It's the appellant's argument that although she's conceding to unfitness, the department did not use reasonable efforts, so therefore the unfitness would be temporary. Thus that, the case should be, as my brother just said, remanded. Again, this case is not the record that supports. In addition, in the first instance, mother's argument contends that the department didn't provide reasonable efforts, and thus her unfitness was temporary. Even if the trial court found that the reasonable effort argument was not waived, in this case, a lack of reasonable efforts is not a defense to a TPR decree. Adoption of Gregory and Iona tell us that. Furthermore, while the mother now claims on appeal that the department failed to provide reasonable efforts due to her substantial barriers and limitations with her mental health, such is not the record before you. In this case, as Your Honors pointed out, before we removed this child, we provided a conditional custody order. The conditional custody order was conditioned on mother complying with certain services.
I get it, but how is mom who has severe mental health issues? I mean, how realistic is that? I mean, standing alone, how realistic is it? You have a woman who has severe, in my mind, based on this record, mental health challenges. An array of mental health challenges. And yet you're acting that she should be able to act rationally. We put her on a conditional custody agreement, and we laid out all the things that we want her to do, and we expect that she's going to be able to comply and do those things. Well, that may be true if she didn't have mental health issues, but we know just by the nature of mental health that it's difficult to do many of those things, in hers particularly, where it's so hyper-paranoid and distrusting. So how can we say, well, we gave her a chance, she signed the agreement, and then she didn't do it? Well, how realistic is that?
So in this case, the FSS services that were put in place immediately, that was supposed to address that, that mother's barriers and her reluctance to work with the department for whatever reasons and due to her mental health. That family stabilization service is kind of a third party. They go in the home, they provide services, they provide the referrals. They kind of take DCF out of the picture.
Did mom engage with that? I know FSSs.
Yes.
Did mom engage with
No.
that?
In fact, we made 3 different referrals. The social worker would go out to the home during this conditional custody period.
So then what?
So after 3 different services, and then when it became that this was now evident that the child was now getting behind medically and everything else, in July, they did a removal of the child. So again, because the child wasn't safe anymore in that home, they tried this family stabilization. They tried to meet with mother. They tried to engage with her DMH worker, which...
I'm sorry.
So that was, they tried everything. This is a woman who was in DMH and had a worker, tried to engage with them, to act. In fact, in the court clinic report, Dr. Selby said that should be the person that use that DMH worker who has familiarity with the mother. But again, with DMH, the way it works, once you don't engage with them, they seem to drop your case.
Understanding it may be impossible to answer this question, that hypothetically, if this were ongoing now with this social worker working with this mother, do you think that consult with a department specialist would be something that might be considered more than it apparently was here, whether it was because of the policy, the ADA policy just having come into effect, or do you think it really was about this scenario in this context?
I think it was about, I don't think a specialist needed to be, a DCF specialist had to be, that's why our policy says it's, the social worker who testified at trial, recognizing the mother's barriers, saying that she had a trauma, and that's why she, in communication, because she recognized the mother's speech, and that she didn't seem receptive to what the social worker was telling her. So she gave both the, when they were trying to explain the permanency goal that had changed, the social worker gave the APM and the supervisor, who have more clinical experience, to try to work with mother and explain things to her. It wasn't successful in this case. Again, we have a mother who has a DMH worker, as an active DMH case. We had everything there. Again, you get to a point where, as Adoption of Lenore, heroic or extraordinary measures, however desirable, they're not required in these cases, because ultimately we need to look at what the best interest of the child is. The department tried, I think the allegation is, well, we should have had an ADA meeting. Well, an ADA meeting, the purpose of an ADA meeting in these cases is when there's a discrepancy, or in the case of adoption made, there was 3 or 4 ADA meetings.
Let me ask you this, was there ever a specific request for an ADA meeting?
There was no request.
There's no claim of ineffective assistance in this case?
No, and in fact, that's one of the findings that the trial judge made, is that when the mother was not engaging with the social worker engaged with mother's counsel, providing her the action plan, and trying to work through counsel, who, the assumption is that counsel has communications with their client, and again, is their advocate. So if they're not going to, so in this case, the department actually tried to really work with this mother. That's why the record on this case is, there's no question that this mother had mental health issues. In fact, the judge, in one of his conclusions, the argument that no one recognized it, absolutely, the judge in one of his conclusions of law says that she does.
Judge Thomas?
Yes, it was Judge Hodgson, I'm sorry, Your Honor. She says, recognizing those barriers, that's why the department put the FSS services in to try to work through those barriers. And the one thing mother did do in this case was participate in that juvenile court clinic. And Dr. Selby came down and said she was very concerned about, if there was any kind of reunification. That purpose was seeing how could mother maybe be reunified with this child. And she said the primary thing would be to make sure that mother was working with her DMH worker, so that there was a liaison who was monitoring her mental health, providing the services she needed. And then after that, then we work on services on seeing if mother can be reunified with this child. But this is a case where mother didn't engage at any point. She, for whatever reasons, and again, mental health is, it is what it is.
You can't say at any point, because she did do the test that you just...
She did.
She would stop, she would seemingly sign the agreement for the conditional custody and then not comply or do anything to follow up or to...
And it seems that things got worse for mother when the child was removed, which is, because she ran into a lot of criminal problems with the neighbor, and there were harassment orders, and then she ended up in the mental health facility for a few months.
Wasn't she incarcerated for a period
And she was
of time
incarcerated. Again, things kind of, but what is also telling in this case is that when mother, even in visits, mother had to be redirected. She would let the child, that was the one thing she was pretty consistent with, was the visits. But when she was at visits, the social worker had to interact constantly. At one point, she let the child run out of the room. The child ended up banging their head on the wall. She couldn't even keep the child safe in that small, supervised environment at the DCF office.
Did she miss about a third of the visits?
She did, but a lot of it due to hospitalization and, mental health issues and just overall not complying with, making sure she called the day before or things of that nature, so that the foster parent wouldn't have to come. So, again, this is not the case where it was reasonable efforts were not made by the department. The department actually made, and the judge found, reasonable efforts at every step of this case. Since the commencement, when the petition was filed, they tried to work with this mother. But at the end, nothing was successful.
See, that's your time. I think we're going to have to leave it there.
Thank you, Your Honor.
Thank you.
I rest on my brief.
Counsel for the child, I say that respectfully because I don't want to butcher your name. So, attorney, I'm not even going to try.
I'm used to my name being butchered, Your Honor.
Attorney Musharit.
Okay, well, there it is.
It's just because I know Attorney Musharit.
Okay.
May it please the court, Michelle Musharit on behalf of the child appealee. In this case, there's overwhelming evidence about the mother's domestic violence, housing instability, criminal activities that undermined her parental fitness. This is a case not about just the mental health. This is a case about domestic violence, Your Honor. This is a case where the mother, although she testified that her relationship with the putative father was, domestic violence was involved, she still continued to associate herself with the putative father. Before the birth.
But how do you untangle that from the mental health?
Your Honors, this is a case about this child and best interest of this child. I understand that domestic violence, how do we entangle it? Facts, my sister just argued that the mother was consistent with her visit. She loves her child, and she's been showing up by herself to the visit. Putative father never showed up. How do we entangle, Your Honor? To your point, Justice Desmond, the services were there for her. She had DMH. Who's more qualified to give her services than Department of Mental Health? She still failed and refused to meet with them, Your Honor. DCF social worker can only make referrals, but Department of Mental Health is qualified. They have the resources to provide for her, Your Honor. So before birth of the child, there was 6 specific incidents that was mentioned in the findings where mother called 911 and the police showed up at her house and the charges were assault and battery on her. Then subsequently, after the child was born, mother called again 911, saying police showed up. The child was present and he was described as hysterically crying. After the child was removed, mother continued her association with this her abuser. Custody of Vaughn tells us that witnessing domestic violence as well as being one of its victims has profound impact on children, and a child who has been either a victim or spectator of such abuse suffers distinctly grievous kind of harm. This child suffered and he witnessed.
I didn't see anything in Attorney Rosenthal's brief that disputes that domestic violence wasn't an issue or mental health wasn't an issue. Visitation, arguably. I mean, I know she did better by way of visitation, but she did still miss several meetings, and there seemed to be some lack of control when she was at some of the visits. I don't know that that's really the complaint. The complaint, I think, is more toward, while she did receive some services, maybe they weren't targeted enough by way of the ADA that gave mom more meaningful support. And so I'm not really sure how you respond to that. I understand the best interest of the child is the North Star. I'm taking all of your time, but how would you respond to that?
So, Your Honor, on the reasonable effort issue, mother had an attorney throughout the pendency of the case. Mother did not raise it. She didn't raise it in the traditional sense, Your Honor. Now she comes here and she says, well, there's issue of reasonable effort. Mother attended every single hearing. There was none. None was requested. But we're here today. Even if this case finds, if this court finds that the mother did not waive her reasonable effort, where's the harm, Your Honor? Where's the harm? You know, I heard mother's argument, and there's absolutely nothing that pinpoints what services the mother could have been offered and benefit from it. So therefore, that argument really doesn't carry much weight. What I can tell you at the end is that the judge's finding of the best interest of the child by terminating a mother's parental right was appropriate, given the circumstances, the length of time the child was out of mother's care, the mother's shortcomings. And although with time, she wasn't able to benefit from the services provided to her. So I would, yeah.
Was it accurate to reflect that while mom was inpatient at Solomon Carter Fuller, she still refused her medications?
She did refuse to accept medication while she was in a psych unit. She also declined visits, and she declined visit when she was incarcerated at South Bay House of Correction. So it's not that the department did not want to work with her. They were willing to work with her. She cannot, at this point, shows up and throws the issue of reasonable efforts and the defeat of the department because she has an obligation. She has an obligation to participate, to appear, and to advocate even with her attorney. She chose not to. So I would say that...
Not because she didn't love her child.
Your Honor, if this case was about love, I can tell you that the outcome would be different because clearly she loves the child and the child loves her. However, this is about best interest of the child. Your Honor.
Thank you. The matter stands submitted.
Thank you.
Our final matter for the morning is John Doe 10390 versus the Sex Offender Registry Board. And second. Get my things here. Attorney Bova.
This is Attorney
Whoops, I'm sorry.
Attorney Bova for the Boyd.
Attorney Ham.
Yes, Your Honor.
My apologies.
May I proceed, Your Honor?
May.
Good morning, honorable justices, and may it please the court. My name's Alex Hahn on behalf of John Doe. I am familiar with what's been known as the 1-minute rule, and I'm happy to waive it if the court would like to start with any questions, or I can proceed to my argument.
Share the 1-minute rule with me.
Oh, the 1-minute rule, I've seen this on the YouTube channel, that it's a rule of the appeals court that they'll give you 1 minute before the justices begin asking questions. So I gather this panel hasn't been that familiar with it, but I will proceed, and I'm happy to answer whatever questions the court.
Maybe judge to judge, counsel. Judge by judge, depending who you get sitting on the seats. That's kind of what it is.
And I apologize, Your Honors. I thought it was
We're almost
more.
at 1 minute anyway.
I appreciate the courtesy that you were willing to waive it. But I'll have you begin, and then we'll probably have some questions for you.
You know what, then? I'm going to jump in, speaking of waiver, because my question is, it doesn't appear there's any objection to the hearsay in the sentencing memo. Was it offered as an exhibit, so why isn't that issue waived?
Your Honor, it's an excellent point. So what I would look at it this way is that, first of all, that objection, even if waived, would not be waived if it's a substantial risk of miscarriage of justice. Putting that aside, I would submit that the substantial evidence requirement survives. So it's not so much as, okay, there was no hearsay objection, so all this comes in or not. But we've still got to look at the corpus of evidence. I'll give an analogy. What if the decision had been based solely on a parking ticket, and there was no objection, and the parking ticket was the sole basis for the opinion? The court would still look at, is there substantial evidence? Because
But when looking at underlying facts of a criminal offense that happened 20, 30 years ago, which are, as the board argues, are fairly static, and that's not really an issue. And when they say, okay, these are the underlying facts, that's what were found in 2009, we're presenting the same facts, and there's no objection. Why is that, again, not waived in terms of just the facts that you seem to be challenging now? Putting aside the parking ticket analogy.
So if we submit that as a technical matter, it would be a waiver of that objection. Again, I'm sort of arguing that the requirement of substantial evidence would still survive, and that the question for the court, I think, on this record is, what kind of adjudication are we comfortable with? Because if we look at the 2009 decision, this decision's a cut and paste from that. It's a wholesale cut and paste. That's A. B, where's the police report?
That's on the facts. I mean, he's been convicted and went to prison, right?
Yes, sure.
And on review, the conviction withstood review. So, I mean, we know that he raped a 13-year-old child, right?
Absolutely. Pardon me, Your Honor. Absolutely. But in a sex offender case, we need more than the raw facts of a conviction. The raw.
She was a stranger. Do you attack any of the factors? Do you take issue with any of the factors that were applied?
So the factors, I think, were reasonably well applied in 2009 and reasonably well applied generally. So the question would be, what's the court's comfort level with not knowing where the facts came from? That yes, there was this pretty egregious crime, but we see the facts in the opinion and in the sentencing memo, but we don't know where they came from. I mean, that's my discomfort with it. In a sex offender case, there's got to be this sort of minute and granular grappling with the
So
facts.
again, counsel, putting aside your discomfort, which you're certainly welcome to have, the issue still for me is you have a hearing examiner.
Yes, Your Honor.
Who is tasked with saying what's the underlying factual evidence. And you have two lawyers there, and one lawyer says, well, let's say they took the appeals court decision from the original case and said, oh, there's some facts right here. I'm going to put these into the facts. And the other lawyer said, yep, those look good to me. Why is that problematic, and why isn't then the issue as to whether those facts were appropriately before the board waived? And then we're starting on a different issue. You may have other issues, but that issue at least we could put to rest.
Yes, Your Honor, that's fair enough. I do have another issue, so I don't want to swim too far against the current of the court at this point.
Nope, not swimming against. I'm just trying to understand it. And
Sure.
Understand if
May I proceed to the other argument?
Certainly may. I mean, you don't have to move from this one if you want to spend some more time on it.
No, I don't want to proceed too far in an argument where essentially the court's views are relatively clear. So my other argument, Your Honors, and I think it's an interesting one, is based on the determination, the requirement of an explicit finding concerning dissemination serving a public safety issue. And this derives from the case 496501, which emerged from the hands of our late, great Chief Justice Gantz, and I think is one of his significant contributions.
And this was before that? This case came before that?
So I don't think so. Doe 496 is 2019, and the hearing examiner does reference 49651. So yeah, it came before this case, yes. So some of the language I think is critical that Justice Gantz used. The examiner must consider what type of sexual crime the offender is likely to commit. He uses the phrase past as prologue. So we're looking here at what was committed and how likely is it to happen again. There's
the examiner said likely to be a stranger girl in the community, right?
Yes, Your Honor, and I think the leaps of logic that are required are monumental.
Okay.
It is 13 years later, and this was at that time, he showed a degree of criminality for sure. There was no other sort of sex crime in this nature. The index offense is sort of this glaring offense, but a one-off in a sense. And do we really believe after 13 years that he's likely to commit this same type of crime? Also, Your Honors, the word efficacy is the most glaringly significant part of all of this, from the decision and other decisions. How does it help to be able to access this man's information on the internet?
And the examiner said parents should have access to the information to protect their children, so that the presumption is because this was a stranger from his church and he's still involved in the church, that other church parents who might have young girls should have access so that they could keep an extra eye out on their kids. How about that? I mean, I'm not taking a position, I'm just asking questions.
Yeah, I think it's a relatively fair question. You're sort of positing a hypothetical scenario.
On the findings.
What's that?
Based on the actual findings by the hearing examiner. So it's not utterly hypothetical because we have an actual crime with an actual human child, and then a hearing examiner made an actual finding based on that. So I'm not being hypothetical. He actually made the finding. Therefore, parents should have access to the information to protect their children. Based on, this was a stranger, child, violent rape, community supervision was not a deterrent for this person, he's got a lengthy criminal record, there were disciplinary reports, and he refused sex offender treatment. So therefore, that's what the hearing examiner, found. What's missing, I suppose is my question there.
And Your Honor, I wasn't intending to say that the crime was a hypothetical, but I understood you to be saying, here's the potential scenario where there is efficacy. That you have parents sort of looking the gentleman up and knowing that, he's at his church and things like that. So again, I think we would have to look at that through the prism of the passage of time. And the fact that he is a pastor at a church cuts both ways. It certainly cuts both ways in terms of, is there a likelihood, is there a concern that he would commit a crime like this? Because we have to look at sort of what the crime was. And I realize it's probably not fair for me to say, it must be the exact same crime that would occur. But he picked up this child, at a bus station and brought her to a hotel. Based on the passage of time, and I don't know that I'd say it's idiosyncratic, this crime, but it's not, there's nothing that suggests that he's a predatory individual.
Do we know whether or not at the time that he was at a bus station or gas station, wherever it was, did he use his position as a member of the church or as a pastor in kind of getting this child's trust?
I don't believe so, Your Honor. So the facts, and I'm sure my brother may be able to clean this up, and I apologize for perhaps not having this right, but he was playing gospel music in the car there, so I do think there was some, sense, and I don't recall if he said, and I'm just going to be very candid, I don't recall if he said sort of, I'm, a pastor, you can trust me, I'm safe and everything, and I'll defer to my brother, and I'm not trying to mislead.
I understand, and then just following, it seems that I'm hearing you say, well, the passage of time, 13 years has passed, and so as a result of the passage of time, he's a different person.
Yes, Your Honor.
May or may not be true. What are we to take that he didn't want to engage in the sex offender treatment? Or that he didn't have the benefit of the sex offender treatment 13 years later?
And we're talking about in prison, essentially?
Right.
So I would say, again, so he gets out of prison in 2007, I believe it is. Yes, he's released in 2007. He's first classified in 2009. His behavior in prison was concerning as well. I mean, so there's no kind of argument with that. And the vast majority of the sort of ecumenical, the pastoral work, I think, comes into the record as his sort of mitigating evidence, rather than this being a case where, God forbid, someone used their position of trust as a pastor. I don't think it's that case. I don't see that in the, I know that we always have, when I'm using the royal we more than I should, but so hearing examiners, judges, everyone else, when there is a position of trust, that is a very considerable concern, with abusers of children, the lifeguard scenario. So that is a concern. But I don't know if we see that here. I would just see it as this guy really seems to have changed himself around when he got out of prison, because we don't see any more violent offenses. We see, some good evidence, some decent evidence of his involvement with the church, and I really think we measure it from then. I understand, the hearing examiner and perhaps the court is going to be compelled by that earlier, evidence, much of it troubling, but I would again say the passage of time, the 13 years, and the science that's baked into those regulations about how your risk diminishes. And I hope the court doesn't mind me getting in a bit of my pet sow, but doing this work, and this is in the case law, how problematic and how devastating it is to be disseminated on the internet.
Sure. Does the risk diminish more if you engage in sex offender treatment?
Oh, sure, that's a factor. So I would not disagree with that at all, Your Honor, that it would have been a lot better if he'd participated in prison. So again, I see it as things, changed. But, so if you try to find sex offenders in Dorchester, Massachusetts, there's a lot of them, man. It's like there's too many to separate the wheat from the chaff. That's sort of the problem here. The registry is clogged. It helps no one. I've had clients who are homeless, drug addicted, can't get into shelters, can't get help for their drug addiction. And that's the guy I passed on the way in who can't get help because he's a sex offender and he's a level 2 and he's on the internet. So I understand, that the court addresses these matters on, case by case. But the rhetoric that we see, the sort of ringing statements from the SJC and from the appeals court are borne out in reality, in my experience, Your Honors. So if the court has any further questions, I'm happy to. If not, I'll rest on my brief.
You had a number of letters of support from well-respected people in the community, is that right?
Yes, Your Honor.
Many of them were not aware of his history?
So I don't think it's certainly established in the record, no, that these individuals were aware of that. And that's going to be the gold standard. I'd have to go look back. But certainly the commendations from legislatures and so forth, yeah, I'm going to stipulate that wasn't sort of, he was a sex offender, he's turned everything around. It's just more that the guy's doing decent things in the community and good for him. And there's evidence about like working against nonviolence and things like that. There's some evidence of real development there and nothing that concerns me. I realize I'm not the court, but, over these 13 years, what we're left with, at least on this record of this gentleman.
To his credit, it does seem that he's doing some good things, no question about it, but the issue here is one of dissemination. And you may have even made the case yourself, given the number of offenders who may be out there, perhaps putting some people on notice of those that have engaged in some egregious crimes may not necessarily be a bad thing.
I think my point is it's hard to really find the bad actors when you've got pastors level 2 out there. That's sort of, and I think that's fairly well established too, that there is a language in the cases that if we over disseminate, it just becomes harder as a parent, any member of the community, to figure out who's real dangerous when you look on the registry list and you live in Dorchester and there's so many offenders around you. That's sort of the issue here. How do you figure out who's the bad actor when John Doe is on there? So I appreciate the court's time greatly.
Thank you, counsel.
Thank you.
Let's see what Attorney Bova has to say to that question.
Thank you. Good morning, Your Honors. May it please the Court, Christopher Bova on behalf of the Sex Offender Registry Board. Before I start the main crux of the arguments that are contained within the brief, I just want to point out that we're arguing this case under the umbrella of the fact that the Board did grant the petitioner's motion for reclassification. They reduced him from a level 3. He was classified a level 3 back in 2009. And in 2021, the case that we're reviewing today, the Board did indeed reduce his level 3 to a level 2. So the Board considered the petitioner's information that he submitted, considered the time in the community, considered his advanced age. They gave a recommended level 2. The petitioner challenged that recommendation because he wanted to be a level 1. And the hearing examiner said, no, based upon the evidence before us, we're going to keep you at a level 2. So that's the factual situation that we're operating under here now. With respect to the reliability issues of the sentencing memorandum, I think, Justice Brennan, you touched based upon the Board's first argument that he had the opportunity to raise this issue before the hearing examiner at hearing, and there was no objection to the evidence coming in. So based upon that, based upon the case law, I'd respectfully submit that that issue has been waived. As I indicated in the Board's brief, even if you were to go on and consider it, I think it's important to look at the underlying Board's regulations, which have the force and effect of law. And those regulations specifically state, and I forget the specific site, but it is listed in the Board's brief, that the Board does have the ability to consider the prior Board decision in making their overall determination, factual determinations. And I think the Superior Court judge took that into consideration in making her decision as well, where she specifically stated to the static facts of the case. And I admit I didn't, and I apologize, I did not submit I did not cite to the SJC case in my brief, but as I was studying for the case today, Doe 326573, which is at 477 Mass 361. It's a 2017 case.
Can you run that back one more time?
Yeah, I apologize. I sometimes speak quickly. It's Doe 326573.
Thank you, Justice.
It's at 477 Mass 361. specifically at page 367, which is that 2017 case, and it says, "A decision in reclassifying an individual is not written on a clean slate." And they basically state that these reclassification motions, now in that case it had to do with a board upward reclassification. We're obviously dealing with a sex offender's motion downward. In that case, later on, they speak similarly to downward reclassifications, but they say, the facts are the facts. They've already been decided in the prior decision. Based upon what we're dealing with now is based upon the new information, whether or not that motion should be allowed. In a board reclass upward, has the board reached its burden? In the case of going down, has the board still reached its burden, but maybe the petitioner hasn't quite, petitioner has no burden, I want to make that clear, but maybe the case hasn't quite made out for a reduced classification. And again, we did allow the motion here. But the hearing examiner was entitled to take into consideration the 2009 decision, the facts of that case. And so the hearing examiner did that. If you compare them, basically it is a cut and paste job. There's no doubt about it. So he did consider that. The Superior Court looked at it and said it's a static situation. What we really need to look at in this particular instance is what's new. What's new? If you move forward, if you want to move a little bit more forward on the reliability issues, I did get into that a little bit more. If you don't believe those first two arguments of waiver or the fact that a hearing examiner can do it and it's reliable based upon the fact that they can rely on past arguments. The sentencing memorandum in and of itself, I would suggest, is something that is utilized in the course, reasonable people will utilize in the course of serious affairs. And that's in the case law I cited to in the board's brief. This was a sentencing memorandum that the prosecutor submitted to the court after this individual was convicted of a very serious crime. It's done time and time again in Superior Court where the courts are respectfully requesting from the parties memorandum with respect to sentencing. The facts determine, I'm sorry, Your Honor.
Was there a memorandum offered by the defendant?
There wasn't anything in this particular record. I don't know what happened. I don't have a particular access to the record that happened in the Superior Court level. It's not in this particular record before the board.
Because part of the argument is it's a government document. Of course, you know, it's a memo that was prepared for the prosecutor after a conviction who's trying to get the maximum sentence, arguably.
I would say he's trying to get the fair sentence, Your Honor. Nonetheless.
Arguably.
I'm sorry?
I said arguably.
Arguably, yes, that is correct. But I think more importantly, that sentencing memorandum filed by the prosecution, even if he is trying to get the maximum sentence, he still has to base that memorandum in fact, in what the judge has heard before the court during the trial. So it's either going to be based upon reports, investigative reports, police reports, or it's going to be based upon testimony that has been borne out at the trial itself. So he's not going to go off the reservation and come up with facts that are really not reliable, so to speak. So I think in and of itself, you have that situation where it does have reliability in and of itself. Then you look at the various factors contained within the case law in terms of you know, consistency, specificity, and detail. And I would suggest that the conviction in and of itself, the case law suggests that the petitioner's conviction in and of itself enhances the reliability of the information contained therein. So I think when you look at the reliability issues as a whole, I would suggest, notwithstanding the waiver and the fact that the hearing examiner can consider it under the regulations, I would suggest the information is reliable, and therefore I would suggest plaintiff's argument should fail.
Well, let me, if I could ask you about another issue, which
Sure.
is, and again, I may be missing something. It seems to me that the cases out there, the analysis of public interest in internet publication is rather thin or sparse, or not a lot of cases out there on it.
Well, 496501, as we discussed, I think it came down in 2019. I'm not quite sure as the date, so we've only had about 5 years to kind of parse that out, yes.
Right. So what is your response to the argument that what the judge, what the examiner, I should say, here found is a little speculative, hypothetical, maybe a bit vague, and doesn't quite get us there?
I would suggest that the
check the boxes, but without anything really concrete holding them up.
I would suggest that the case law, as we all know it, says you have to look at the individual case. It's a case-by-case analysis. And I would contend that the set of facts that we're dealing with, the conviction that we're dealing with, kind of speaks for itself. I know counsel cited to two cases, and I kind of distinguished those cases in my brief. I think when you start getting into the gray area of public dissemination is when you have those cases where you're dealing with maybe an intrafamilial victim, where a question could be raised as to, well, what is the benefit of public dissemination if the crime itself was only contained within a intrafamilial situation? Clearly, we don't have that here. As clearly, this is probably, while not a lot of these cases come to light, this is the case that usually you see on TV, where somebody picks somebody up in a public place, takes them off, takes them to a hotel, and rapes them. I'm not saying this case was on the TV or anything like that, but this is the type of case that we see. So when you're talking about whether public dissemination is important, when you have an individual offending against a stranger child victim, as defined by the law, a sex offense involving a child, I think those are the cases which require dissemination, specifically for the reasons that the hearing examiner outlined in the decision, because the statute is based upon that. And I think Chief Justice Gantz in 496501, I think the Chief Justice even recognized that, where he said, when you have a child victim, you have a hands-on sex offense, almost invariably public dissemination is going to go along with the risk of reoffense and degree of dangerousness.
Any discussion here, I just don't remember, honestly, as to the sort of dual impact of this doe being a pastor. So on the one hand, you have letters from folks in the church saying, doing great things out there. On the other hand, and if the situation with the Catholic Church hasn't taught us anything, we know that it gives special access and it's imbued with some level of trust and presents opportunities where they might not otherwise exist. Was that at all discussed, or is that just sort of overarching this from your read of the record?
In my recollection of the hearing examiner's decision, the hearing examiner certainly talked about his pastoral job under, I believe it was under Factor 33 and Factor 34. I argued in my brief, and I understand it wasn't necessarily written in the hearing examiner's decision, that the letters submitted by the petitioner indicated he still has access to children, that he's actually reaching out. I don't believe that the decision, actually I know that the decision does not specifically speak to that, so that is solely an argument that I made based upon the record evidence, which I would suggest even bolsters the fact, notwithstanding the hearing examiner. So if it were to go back and the hearing examiner was aware of that, certainly I think that would increase the reason why the hearing examiner would require public dissemination.
So does that mean that he's going to be required for public dissemination forever if he engages in this type of work-related business that he's in? I mean, he's got 13 years without incident. He's got public support. He's in the community. I mean, at what point do you say maybe it's not necessary for him?
Absolutely, Your Honor. I'd answer it this way. So, like I said at the beginning of the argument, the board did reduce him from a 3 to a 2, okay, based upon that information. And certainly time in the community is an important mitigating factor, as is age, okay? And to answer...
54, not quite 60, but he's getting on.
Exactly. And to answer your question, Your Honor, regarding sex offender treatment and how that applies in terms of mitigation, it's better to have sex offender treatment, and actually this petitioner did not, obviously. However, I would concede the fact that time in the community and age are very important factors. So even if an individual did not undergo sex offender treatment, the fact that he continues on in the community kind of takes the sex offender treatment factor out of the equation, because he's already shown that he's gone 13 years without offending, even without treatment. So that's, in my experience, that's what the evaluators and the experts, when they come in, not that there was an expert in this case, but that's what the experts would testify to. With respect to the age, you have a little bit different circumstance in this case, because as Your Honor indicated, he is in his 50s, and based upon the board's regulation, if you have a child victim, you don't get full mitigation until you reach age 60. So I think the hearing examiner did apply that factor correctly. To answer your question specifically, he is eligible for reclassification as we sit here today. So if you remand it, he could get a hearing based upon a remand. If you uphold it, he can file for reclassification. He'll get a hearing for reclassification. Now, looking out, he will get a little extra time in the community. He'll get a little extra with respect to age, but you still have a situation where he would not have reached age 60. So I don't know how much difference that's going to make if he were to, but he does have the right every 3 years to file reclassification, providing the fact that he doesn't have anything additional coming forward in terms of criminal activity, sex offenses, and the like. With that, unless there's any other questions from the panel, I will rest on my brief.
Seeing none, the matter stands submitted. Thank you both kindly.
Thank you so much for your time. I appreciate it.
Appreciate you.
Have a good weekend.
All right, that's our business for the day. We are in recess.
All rise, please.
Thank you, Ronnie.